Good evening from Los Angeles, and welcome to a special edition of America Tonight. I'm Michael Oku. Think about your life for a second. Do you own a home, a car, a cell phone? Do you go to the doctor or a dentist or download music on iTunes? Well, then chances are you have signed away a fundamental right, the right to have your day in court. It's called arbitration, and for the past 6 months, we have talked to dozens of experts and combed through thousands of cases to see how arbitration affects you. You might find the results surprising, if not shocking.
Everywhere you have to sign these agreements.
You're going to sign it.
Arbitration is the name of the game.
Tens of millions of consumers are players in that game, where the opponent sets the ground rules and picks the referees, and yet few of us even know it exists. Paul, what in a nutshell is arbitration?
For the vast majority of consumer transactions, corporations put forced arbitration clauses in the fine print of their contract. And what these arbitration clauses say is that if they break the law in some way and you have a legal claim against them, you can't go to court, you can't have a jury or any of those sorts of rights, but instead you're going to go to a private system that they set up, essentially. And there's going to be a private judge who's going to be picked by a company that they've picked. And whatever the private judge does, you really can't appeal it to court in virtually any circumstances. And that the whole system is essentially mostly secretive. And so that's forced arbitration.
You've probably agreed to arbitration dozens of times. It's right there in the fine print. How easy is it to read those specific clauses?
The vast majority of arbitration clauses are written with the idea of making it impossible for people to understand. So for example, I had a case against a payday lender. The first sentence of their arbitration clause was 256 words. It had something like 28 different pieces of punctuation in it. So
You said the first sentence?
The first sentence.
Homes, cars, loans, cell phones, credit cards, just about everything these days comes with an arbitration agreement.
There are cemeteries that require people to sign an arbitration clause before you can take your loved one's remains to them, or that they will handle them. There are pet boarding places that require arbitration clauses before they will take care of your animal. The vast majority of nursing homes in America will not take a patient in unless there is an arbitration clause that's signed. There are arbitration clauses for nearly any new home that is purchased. A lot of people who repair homes require you to have an arbitration clause. If you're going to buy a new car, virtually all new car purchases have an arbitration clause attached to them. Most used car purchases in America have an arbitration clause attached to them.
I'm exhausted just listening to you. You've mentioned basically anything I might be doing during the course of a normal day.
It is hard to come up with many examples of businesses that don't require their customers to give up their constitutional rights.
Very few people realize what they're signing away when they sign these mandatory arbitration clauses. They are basically giving up something we value, your day in court, your ability to take your claim and have it decided by a fair judge or by an impartial jury. You give that up.
When Congress passed the Federal Arbitration Act in 1925, it was supposed to settle disputes between large companies and was intended to be purely voluntary. And it was until the 1980s, when a series of court decisions paved the way for arbitration to be used with consumers. Recent Supreme Court decisions have only strengthened arbitration's reach. So now, cases that would have gone to open court are increasingly heading out of the public eye and into conference rooms, and few know about it.
I'm sorry to tell you, I really don't know what forced arbitration is.
But Mike Sanchez agreed to it when he signed paperwork on his first day working at CarMax.
In this case, for employment, it's forced. You're obligated. And if you don't sign it, you don't get the job. I need a job, and I had to sign it.
It wasn't an issue until he got fired.
I reported through email, which is customary, that we had some issues with cars' safety. And soon after, I was terminated. My friends did tell me, this is not fair, it's not right, and you should sue them.
That's when he learned what he had given up.
I signed my rights away, and I'm experiencing it firsthand, and it's unimaginable.
CarMax, which didn't return our calls for comment, has denied wrongfully terminating Sanchez.
I think what isn't unusual about your story is, one, the fact that he discovered he was stuck with arbitration, couldn't go to court, and he is probably stuck with an arbitration system that favors his employer over him.
Elizabeth Bartholet is an employment law professor at Harvard.
Corporations are now regularly saying to prospective employees, if you want a job, you have to waive your right to go to court for any civil rights violation, indeed for any violation of law.
If I was an employee somewhere and my boss passed me up for promotion and openly said to me, I don't like the fact that you're married to an immigrant, I couldn't take that to court because I had signed an arbitration agreement.
Absolutely. If you had signed an arbitration agreement, even if you didn't know you'd signed it or you didn't read the fine print, you would be limited to the arbitration forum. You would not be allowed to go to state or federal court.
The reason that you go through arbitration or the reason that you bring a lawsuit is to have a right vindicated because you have had a problem in some way and you need that problem resolved. And I don't believe that having that problem resolved through arbitration is worse or less fair than having that problem resolved through court.
Kim Stone is with the Civil Justice Association of California, which advocates for arbitration. Its board of directors includes some of the biggest names in industry: Apple, ExxonMobil, and Johnson & Johnson.
The idea that employees are disadvantaged by going through arbitration is not true.
But they're also
not supported by evidence.
She pointed to these two studies done in the 1990s which suggest employees do just as well in arbitration as court. But a 2012 Cornell University study found employees lost 80% of arbitrations. And in 2007, Public Citizen, a consumer advocacy group, found credit card consumers lost 94% of the time. Would you say that this system is skewed in favor of corporations against consumers?
It's absolutely skewed in favor of corporations, both against consumers and against employees.
Bartholet speaks from experience. She used to be an arbitrator and heard credit card disputes.
I ruled for the banks with no qualms.
How many times would you say you did that?
Roughly a dozen. And then came a case where it seemed the consumer was right. I ruled for the consumer and ordered that the bank had to turn over some money. And after that, I found myself in every single case until I resigned, disqualified from arbitrating. So I was disqualified by the bank in every single case that came before me after that.
What exactly was this? Do you think it was retribution, or they just did not want you to try their cases anymore?
I think it was pretty clear that they expected all their arbitrators to rule consistently for them, and when they found an arbitrator that was willing to consider the other side, they disqualified that arbitrator.
You don't have to tell them twice that too many verdicts in favor of the plaintiff or too high a verdict for the plaintiff is going to mean a drop in your own income.
Lawyer and doctor Arlen Cohen says arbitrators can make as much as $900 an hour.
When you think about this, if you work 25 hours a week during the course of the year at that rate, you're talking $1 million a year. And some of the arbitrators, particularly those who are in demand and are very busy, can earn that much working 25 or 26 hours a week. And it's a source of income that it's only human to want to preserve.
That's where the so-called repeat player effect comes into play. Arbitrators may rule favorably for a frequently sued defendant in hopes for return business.
There was a case a number of years ago, which was a case of a baby injured in the course of labor and delivery, where we were pretty certain that a baby who was badly injured deserved to be compensated. And during the course of deliberation, the neutral told my party arbitrator, either this baby gets $6 million now for his future care over his lifetime, or I can earn that as an arbitrator over the next 10 years. But both of those can't happen.
The arbitrator ruled in favor of the company. The baby lost.
It's a relatively lawless regime, even if you assume that the arbitrators are not biased, are going to be fair. If they're ignorant, if they get the law wrong, it doesn't matter because it can't be appealed.
What are we risking in all of this?
We're risking our justice system. We're risking a system that's designed to provide even-handed justice, that has its flaws. It's too expensive, it takes too long, but it is designed to provide unbiased, even-handed justice. That's what we're risking.
To find out how fair the system is, we took a look at 10 years of medical malpractice arbitrations in California, nearly 1,600 cases. Our research shows you are twice as likely to win in front of a judge than an arbitrator. We focused on California because it's one of the few states where arbitration firms are required to publish basic data about the cases that they handle. Information like who filed the case, what the case was about, what, if any, award was granted. So we took a look at 20 firms and discovered that only 4 firms were actually complying with the law. The rest of them are breaking it. Information that's required by law to be public is missing. In 2013, a University of California Hastings Law School study found similar results. We asked California's top law enforcer, Attorney General Kamala Harris, what she planned to do about it, but her office had no comment. It's the sobering reality of arbitration, what attorney Catherine Stepner calls a secrecy, which keeps important information hidden from the public.
If you want to put your mom in a nursing home or your dad in a nursing home, you're not going to know how many times they've been sued. That's not information that you can find. Whereas if it's in the courthouse, if you're in Los Angeles County, you can go to the courthouse, and you can go online and you just type in the name of the nursing home and you can see all the times they were sued. You can get the documents. It's all public. You can see exactly what happened. In an arbitration, silent.
Coming up, losers can pay dearly in arbitration.
I just sat there and I couldn't talk. I just didn't know what I was going to do.
In 2008, Arizona resident Katie Ideas was trying to jumpstart a career in the medical field.
I went and looked up online in Phoenix, where I was living at the time, for schools that taught surgical tech programs, at which time I found Lamson. This is the actual handbook they gave me.
She eventually learned her $25,000 diploma wouldn't get her the job she wanted.
And I was told that I couldn't get a job, and another student who I had kept in contact with told me that he was advised that an actual administrator at a surgical center told him that they would never hire a Lamson student at their surgical center because of the substandard education that we received.
Feeling they'd been defrauded, Ideas and a few other students wanted to sue Lamson College to get their money back.
I contacted the lawyer, and he said that yes, they were going through with a class action suit. And once I signed the paperwork for the lawyer, then that's when I found out about the arbitration.
Lamson had included an arbitration clause in its paperwork.
I had no idea what arbitration was. Arbitration didn't really mean anything to me.
She soon learned instead of a judge or jury, her case would be decided by an arbitrator. That arbitrator eventually ruled against her and ordered her to pay Lamson's legal bills.
Not only did we lose our arbitration, but we currently owe almost $400,000.
I think this is a terrible injustice.
Senator Dick Durbin has a bill pending that would ban mandatory arbitration clauses from for-profit colleges. Ideas' story isn't a surprise. It's reasonable to believe that had she had her day in court, she may very well have won that case.
This was classic deception and fraud. And to think that she didn't win in the arbitration tells you the odds are against you. Once they've set up these arbitrations, 9 times out of 10, you just don't have a chance.
Well, she didn't win in the arbitration, and to make matters worse, she and the other plaintiffs are now on the hook for $400,000 to pay for the other side's legal fees. Is that fair?
That's an outrage.
with over $100,000 in debt for an education I can't use, it puts me in a very, very hard position. I don't have a future in the job that I have right now because the diploma is not worth anything.
Lamson couldn't be reached despite repeated attempts. Some schools are going beyond Lamson's arbitration agreement by banning class actions, which allow people to sue as a group.
Think about this for a second. These students individually cannot go to court and sue University of Phoenix, DeVry, Kaplan, ITT. They're not going to have the wherewithal. And if they're not careful, if they're on a mandatory arbitration clause and they lose the arbitration, they may be charged with attorney's fees to pay back the school for even questioning the policies.
Nearly every arbitration clause that's currently used in the United States explicitly says that a consumer, worker, whatever, is not allowed to bring a class action lawsuit or join in a class action or participate in a class action. They require you that if you have a dispute against them, you're going to have to bring it and prove it entirely by yourself.
So it's a get-out-of-jail-free card for companies.
That's exactly right. They simply make it next to impossible to go after a company even if it breaks the law.
Class action lawsuits at one time were like noble means to right righteous wrongs. Class action lawsuits have now become, in many cases, lawyer-driven lawsuits about the olive oil not being extra virgin enough or my granola bar not really being natural.
Kim Stone is president of an industry group that lobbies in favor of arbitration as a better alternative to class actions.
Class action lawsuits that I see and that I encounter are where the lawyers get millions and we get much less money.
As far as the individuals are concerned, though, it's the one way that the everyday consumer can hold big corporations accountable.
But I'm an everyday consumer, and you are too, and probably some of your viewers are too. And every time I've received a postcard in the mail about a product that I bought that I'm a member of the class of, I don't want to sue the company. And so I don't feel like my rights are being vindicated because some lawyer at Humada Ding Ding is getting $2.5 million, and I'm a member of a lawsuit against them.
But trial lawyers may not be getting as much of the pie as people think. A 2015 report on arbitration and class actions by the Consumer Financial Protection Bureau found attorneys took 18%, less than a third of settlement money. The study also found people do better in court. Consumers collected $2 billion from 420 class action settlements, but they got less than $175,000 among 1,000 arbitrations filed. Even though companies sign up millions of their customers through arbitration, those customers rarely end up using it. Take T-Mobile. It has 63 million consumers, but by our count, it faced 44 consumer arbitrations in the last 5 years. And Comcast, with 27 million customers, faced 23. And arbitration isn't always a two-way street.
You sign away your right to a jury trial, okay? But if you don't pay your rent, or if you owe them money, or they want to sue you, guess what? They can take you to court.
I didn't believe that somebody could take my right away but still keep their rights at the same time.
They also sometimes dictate, many times dictate, like who has to arbitrate it, the rules around the arbitration, which rules are going to apply. They might say the state of California that applies, the state of Kentucky applies, or wherever.
Or in the case of the cruise ship industry, Malta. Despite a federal law guaranteeing injured ship workers the right to sue in America, they can be ordered to arbitrations halfway around the world.
There are arbitration clauses that people sign that on their face are saying that the arbitrator doesn't have to follow the laws of the United States.
Why is there no public outcry about this? I mean, what you're describing doesn't even sound like justice.
The reason that there was almost no public outcry about arbitration is that very, very few people in America understand the rights that they are giving up every day. When I talk to people who come in to me and they say, this terrible illegal thing happened to me, and then I tell them, well, there's nothing you can do about it because there's an arbitration clause, that's the first time they've heard about it, is when I told them. Almost nobody that you meet on the street is aware that they are giving up these rights.
Next, cases are being decided not by a court of law, but by the Word of God. What was Nick like?
Nick was funny. Nick was smart. Nick had the best sense of humor and very, very quick-witted.
You had fun with him.
I had a blast with Nick.
Sheree Spivey is talking about her oldest son, Nick. Growing up gay in Knoxville, Tennessee wasn't easy.
It was something that was not acceptable. And he, had to deal with his identity.
When he started drinking heavily, Spivey sent him to a Christian rehab program in Florida called Teen Challenge. You sent him to a detox program.
Yes.
What exactly happened?
When Nick went there, the first thing they tried to do was de-gay him.
They tried to de-gay him.
To de-gay him.
At a detox program.
Yes.
And that drove him to drink.
He ended up stealing cough syrup from a store when he was on a job site and drinking that.
Teen Challenge kicked out Nick for breaking a rule, Spivey says. Hours later, he died in an overdose. Did you actually try talking to them?
I tried to find out what happened to Nick, but when they would continuously lie, I knew that I was not going to get anywhere with finding out what happened to my son. And I have never sued anyone, but I wanted to know what happened to Nick.
A lawsuit would force Teen Challenge to answer Spivey's questions, but she found out that wasn't an option. There was an arbitration agreement. When you were told that you couldn't sue and that you had to go through arbitration, did you even know what that meant?
No, I actually had to Google it to try to find out what it meant.
And when you Googled it, what did you find?
It was a lot of lawyer word.
Did it make sense to you?
It didn't make any sense to me.
But the arbitration clause was signed by Nick, not her. Why would this apply to you? I mean, Nick is the one who signed this.
I never felt like it should have applied to me because of the fact that Nick signed this.
Instead of following the laws and the books, this arbitration would be decided by verses in the Bible. This was a Christian arbitration. How is it going to work?
There would be a couple of other Christian people there, and that we would just talk it out. Talk it out 8 hours one day and go over the Bible and what the Bible says about it, and then 8 hours the next day, come to an agreement. If we didn't come to agreement, then it would go to another level. I'm not sure what that level was.
I suspect that you had to know that you weren't going to get justice by praying. You were going to get it in a courtroom.
Exactly.
Religious arbitrations are being enforced by courts nationwide. Was this going to cost you anything?
Yes. It was going to be up front $10,000. And then
$10,000?
$10,000 up front. And I'm not sure where that money was going to go to.
You realize that if you go to court, there's probably a $100 filing fee.
Right.
And then you have your day.
Right.
Did you find it to be crazy, ridiculous?
Absolutely. There was no possible way that I could have come up with $10,000.
She says she was also told her attorney could be present at the prayer meetings, but couldn't speak. Whatever was decided would be final and binding. It couldn't be appealed. You know, Sheree, some people are going to hear this and think it's absolutely nuts that you have to resolve this dispute by reading the Bible and praying rather than going to court.
I could pray all day and do, but I couldn't go in there and read the Bible and what they said. I know the Bible probably better than they do, but then just hug them and kiss and make up. I couldn't do that. Nick's voice never would have been heard, never. And that was important to me to get Nick's story out there.
Teen Challenge, which wouldn't comment on this story, eventually agreed to a confidential settlement with Spivey. While she wanted